Alright, let's dial into another video. I felt compelled to do, and I think this is going to add another layer of depth to the often, I know we get it happens regularly. It happens with me of trying to establish the separations of common law and our interest in those matters of equity and rights of parliament and such. So um, hope you enjoyed this video. I'm going to read from my own script that I wrote and see if I can keep on track. Here it goes. I was asked a question concerning the recent coronation oath and how that applied to my research concerning that the monarchy has the duty of fideicommissium, who is chosen by society to hold the land in trust for the people. To begin, I was forwarded a half an hour video concerning a talk presented by David Starkey at a yacht club in Dover titled King Charles Coronation, Why Does It Matter? Not knowing where I was going to arrive at through this presentation, meaning would it serve to discount or reaffirm my research into what is English law, as either is warmly appreciated, and that the origins of our inalienable rights to free will autonomy and the absolute right to the use of the soil without first having made an agreement, I was able to extract some key points so as to provide a deeper perspective on my current research into what is law and those unalienable rights. The question essentially was in relation to what David Starkey surmises in his talk, basically that the coronation oath created immediately after the Declaration of Right given or granted to William and Mary of Orange to sit upon the English throne, namely, was to adhere to the statutory rules made by Parliament. And then, since 1931, there was no longer a monarchy swearing to this as a part of the coronation oath, for the reason, I gathered, was that the Queen was broken up into independent heads of state, which then the Queen swore an oath to uphold the laws of each independent territory according to their laws and customs, so not to those statutory laws made immediately by English Parliament. This arrived in the query as to whether King Charles III coronation oath gives him the power of king if he has not sworn to uphold the laws of Parliament. That was a part of the coronation oath beginning of 1689. Since I speak only to a matter of law and not those directly tied to Parliament and government, I tweaked the question a bit in support of how it relates to the monarchy regarding the right of possessing any power at all, as it pertains to me thereafter claiming the sovereign as fideicommissium, as I do in my business card notice that I have shared in the public more recently actually, whereby I am the original grantor through operation of law of the right to the use of lands that then are granted through trust for government and its citizenry. Through my recent investigation, and now I'm pleased to say that my research is again affirmed. The monarchy still holds the land in trust for the people, and so immediately you have a right to a legal estate. But before I provide any proof of the power and duty of the monarchy's title to hold my legal estate and yours, I want to digress for a bit to speak to another topic that is being expressed more recently by such groups such as the Peacekeepers, or conveyed through people like Simon the Spaniard and other equity-hugging platforms, who all, while using and expressly confirming to common law and rules of equity through their very own actions, who are attempting to either discount or debate the right of Parliament to enforce or to create statutory laws, which bind each individual regardless of their agreement, and or proving that you created the money through signature, and so are essentially the creditor depositing real value into a bank, or that you are bound to slavery, such as the church capturing the placenta at birth, or the government has bonded each life in perpetual, there, right there, perpetual servitude. Perpetual servitude, that's what I meant to say. I'm not going to edit that out, obviously. And so hypothesizing that the government is your master, etc., etc. So let's start the right of Parliament, and in fact, through legislation, affects an obligation in each citizen to comply based on their legal personage. To the extent, and in expectation, that I will not receive any popularity points for siding with the likes of Belt Barrister, and so support his reasons of why one is obligated to pay such an idea as council tax. I ask that you perhaps indulge me in this video so as to give factual reasoning for my stance. The main reason with all included groups and trusts, individuals as well as lawyers, is they are never, ever affecting the originating English common law. None are. In fact, the bar unit itself debates most often territorial laws and its customs, and or the estates managed through English Parliament. So, do not debate the English common law in their courts of chancery. Why? Because simply the English common law subject matter that I speak to, and itself speaks to, is not the same subject matter that the majority speak to, since the majority are affecting the rules of equity first, subject to a trust which separates the English common law subject matter from the subject matter of those estate interests created in equity, that then form the territorial common laws, whereby subject matter must be of the same in order to be debated in any court. So, if a conflict arises between the parliamentary and government common law with a matter of equity, equity will prevail, but only if they are first of the same subject matter. Thereby, never can equity overreach the English common law, as it is that illegal state held in trust, so as then to establish a beneficial use of this legal estate. In fact, here is the main point that I will also give hint to the separation of powers in the monarchy versus Parliament and government. The monarchy has to, through oath, surrender the hereditary revenues to the UK government, including the Crown Estate, which means the reigning monarch must have initial possession first in each initial exchange of sovereignty, in order to then transfer this equitable right to the UK Parliament. Correct? And by the way, with some people who state that they are sovereign, I will read a line from one of 4 oaths King Charles made. Hint, 3 are statutory and 1 is not. Whereby he states in his non-statutory oath, in mid-sentence he states, and of the duties and heavy responsibilities of sovereignty, which now pass to me. Did you catch what he said? If you claim sovereignty, means you have a successive duty to perform, which means you have now created an obligation. And so, in contrast, to be recognized in your own right, such as sui juris, and so the inherent right of dominion, you would not claim being sovereign, would you? Because to say you are a man or a woman of nature, and next say you are sovereign, runs in contradistinction in the same manner people generally commingle law and equity, and thinking they are the same. Now returning from my now triple digress, let me return to the origins of my first digress, namely to speak to the power of Parliament, to enforce its laws upon its citizenry, dependent upon their noted status against the property rights each holds. Parliament has its prerogative to create any laws that it has granted, that it was granted through its creation. And these next words are very important. Not only judicially proven throughout the history of succession, not unlike any institution recognized today, but more importantly that the acts of Parliament and government do not ever interfere with the inheritance of the people, that the monarchy is holding in trust to the power and duty of its title. So when Parliament and government create laws, like council tax, motor vehicle statutory laws, rights to property that itself has been granted to administrate over, etc., etc., meaning ever since the power acknowledged through the oath given by the king about a century after the Magna Carta, means parliamentary acts do absolutely create an obligation in every citizen who then agrees to control any interest under the administration of government, period. As David Starkey himself simply puts, I'm paraphrasing here, that the judiciary has a standard measure against all laws created by Parliament, and that measure is to determine if whether a bishop or nobleman, or as a citizen represented through majority vote, is if each voice is being properly representative and represented according to each status and witness agreements. The answer is a resounding yes, albeit not in the manner some of us are interpreting the system, but this general interpretation is of no matter when it is the courts who establish the jurisdiction and so is solely dependent upon your status and the subject matter you are speaking to. And so, as I have already proven through law, that this pledge contrived by the Peacekeepers, albeit it is noble in its concept, is futile unless they can prove that the entire system has no power over the contracts and trust itself then creates under itself, or creates those under itself. To see how we get to absurdity? It is that who then creates those trusts and contracts, then manage those trusts and contracts, to which through noticed agreements, then prove those trusts and contracts that that person is there under. Okay? We can't dodge what we've agreed to just because we don't like them. And we'll get into that a little deeper here. It is essentially, well, in fact, all equity in law is over agreements, period. So not over people, which are against the states, held in each. Okay, that is what agreements deal with. Estates that are held in each, to which then people then create an obligation by their notice agreement to then hold one of those estates. To the extent it even says so in the first line of the Bill of Rights, 1688, as it clearly states, whereas the Lords Spiritual and Temporal and Commons, assembled at Westminster, lawfully, fully, and freely, representing all the estates of the people of this realm, unquote, to which the Peacekeepers themselves also include, with this bill, the Act of Settlement 1700. By the way, because it says act, what kind of law is it? Just give you some moment to think about that. Whereby the Act states that the English law is the birthright of the people. Wouldn't it then mean that we are speaking to the estates are of the birthright of the people, since English law refers to a land interest first, not concerning the rights of people first? As for the Spaniard reference that the legal state is bollocks, that there is no trust value held before the beneficial use realized in society, let me ask you, Simon, what exactly creates a beneficial interest? I will ask. Key word is beneficial. He says there is a benefit in the Cestui use. So what has to come before this right? In the Cestui use, and next the rights afforded to the Cestui trust, to serve as a principal subject matter being held in trust in order for a benefit to next be derived therefrom. What is a trust? and what is law to which he speaks to equity only, and admits to it, thereby automatically self-defeating not only the trust that the equitable interest is being derived therefrom, but obviously the legal state held in the common law that is the principle being used to create the benefit that he is referring to in equity. Another interruption here to insert another thought. Land, and to create more clarity of course, land is the only thing English law then creates rules of action against, either seisin or season or seisin and or possession, not the people. And as for land, means not the soil, but rather quality, like tenure and status, or quantity, like a life or fee or other limitation called entail, to which then establish every other subsequent action over estates and property under those rules of action in equity. I return to the main reason I am doing this video, so as to answer the question as to whether the monarchy is a valid title. Thereby will then support, through syllogistic reasoning, my research into law, which historically traces each individual's right to vest our own legal estate, created at each individual birth. Well, I feel another digression coming on. Just forgive me here. What does the very first registration of birth record? I know a lot of people know this. And please, do not bring in placenta theories into this when the creator of this theory does not even know what law is. And this registration is the one I'm speaking to at the hospital, signed between either parents or parent and the practitioner. Hint, is a registration of an event, not a life. Thereby, how can one be born into slavery if they were never recorded as a species of nature by the monarchy or of government? We need not to only think deeply, okay? We need to think clearly. How is it that we are then thinking we're forced into slavery, into an involuntary servitude where one, they don't even record you as a live human, okay? But secondarily, it is written in law itself that slavery is abhorrent to English law. So how could law be lawful if, well, you can answer the rest of that question. The first oath Charles III makes before he is crowned some 7 to 8 months later is a non-statutory oath. Means not with the right of repeal existing in Parliament. To add more depth is this recorded lawful truth: that land can never be held in abeyance. Hint, what is land? We've already discussed that previously. And so, as relates to those estate interests held only in the English common law, means once one estate ends in common law, it must be able to be immediately transferred into the next successor through the laws of inheritance, as there is no heir to the living in the common law, or is the common law inapt to obtain future executory interest. Why? Like we have learned that common law was constrained to livery of seisin or season, it was witnessed in the now through ceremonial transfer. So what I'm speaking to, as it seemed to be a bit of a lapse in how I sort of added those two thoughts together, I'll further develop it. In common law, it cannot be orated or expressed to be a transfer in the future, even if one wrote to A for life and next to B and his heirs in 15 minutes from now. As soon as you declare that transfer was to happen any time in the future, the action itself is void at law. Legal states and common law happen in the now, period. Now let's read from the first oath made by Charles III immediately after the death of his mother. Here's a quote from the paragraph. I'm not going to read the whole entire oath. I'm just going to work on one paragraph. And this is his first oath, the non-statutory oath. He reads, I am deeply aware of this great inheritance and of the duties and heavy responsibilities, sovereignty, which have now passed to me. I am taking up these responsibilities. I shall strive to follow the inspiring example I have been set in upholding constitutional government and to seek the peace, harmony, and prosperity of the people of these islands and of the Commonwealth realms and territories throughout the world. Now let's break this apart a bit. I will attach a link explaining this very oath that I'm reading from, and so the one I used, of course, the quote from, and as well as David Starkey's interesting video, and the link regarding an overview concerning the transfer of hereditary revenues and the Crown Estates. Please remember, right now, in fact, if you want to be in common law in the now, hit and smash the like button and subscribe if you haven't done so, and please also share. And of course, every donation is greatly appreciated. I wish to thank all those who have donated so far, because I think that they can appreciate the depth that is brought forward in all of these videos to help us comprehend what law is. But of course, those who have done studies themselves know that it takes thousands upon thousands and thousands of hours to now discover each thing and unveil each act to then arrive at the quintessential point, which is through the idea of Occam's razor, where instead of using the Aristotelian approach, where you just keep on adding facts and facts and facts, like the science today does, you remove all the facts, or you remove all the impurities, and to get to the gold, to get to the diamond, to get to the core fact or the core truth. Okay? So, the first sentence reads, I am deeply aware of this great inheritance and of the duties and heavy responsibilities of sovereignty, which now pass to me. I don't know why I'm having on and off problems with that word today, but it happens. The key word I wish to extract from this sentence is inheritance. This is a common law inheritance, not an equitable inheritance, and is done through the strict settlement rules, not subject to those of a trust. Okay? This is the common law, like we spoke to the delivery of season, where it is done now, and it is done strictly through rituals. Nothing to do with documentations that are then created through deeds and so forth and passed on. Okay? Those interests held in the Queen are automatically transferred to Charles III as now recognized heir. So this has nothing to do with Parliament, but the people who allow Charles to now hold an individual interest. This is a non-statutory oath, as already mentioned, for the reasons just expressed. The transfer of this inheritance has to be made and recognized immediately, since the common law rule is land cannot be held in abeyance, and is done by immediate delivery of this interest. So who holds this interest after the oath is made? Now holding this legal estate, he can then lawfully affirm dispositions according to the statutory oaths, which can be recognized as the whoops, I put that word in accidentally, and again I am not going to edit this, but maybe I'll read from the beginning there. Now holding his legal state, he could then lawfully affirm the statutory oaths, which can be recognized as the disposition of hereditary revenues and crown estates, that then makes him merely the right to the beneficial interest as merely an annuitant, but does not transfer his superior right to the legal estate itself, as that remains in the monarchy. The same thing when it's granted to Parliament. It never never transfer the superior legal estate into Parliament. Parliament cannot hold that interest. They hold a second level interest through equity and subject to a trust. If it never, and here's the question, if it never remained in the title of the monarchy, and to those people who say, well, the monarchy has no power, yada, 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 then why do the ritual at all? He goes on to say he will uphold the constitutional monarchy. So essentially meaning he's affirming and maintaining that Parliament. Okay? Parliament cannot be greater than its creator. He will seek the peace, he goes on to say, he will seek the peace, harmony, and prosperity of the peoples. So because we are speaking of the common law legal estates, means the word of, used in this phrase, refers to possession. And next, the word of, directly thereafter, which states of these islands and of the Commonwealth realms and territories throughout the world, I would then read the word of, while keeping in mind I'm speaking to the subject matter Charles III is referring to mean in association and our belonging. Little trivia note here. After I looked up the word of, did you know that the word of had 21 definitions? And so why it is important to first know your topic. Because, again, it's not only thinking deeply, it's also thinking clearly. With that, I hope you enjoyed this video. And now we'll have a deeper and clearer comprehension of what is law in those matters of equity, as well as now realize that the power to hold these legal estates first belong to the people is in the title of the monarchy, which the laws of inheritance and those limitations of succession will always reign supreme, before any manners ordained through Parliament, or to a lesser extent, those of citizenry. If you haven't hit the like button yet, by all means do so. And if you don't like it, and you'd like to leave a comment where I am, way out in left field, I don't know what I'm talking about, that, believe me, is equally important because it allows me to develop. If you can either A, speak the subject matter, but if you're not speaking the subject matter, then I will also offer my advice on that as well. And with that, thank you for listening. And now, hopefully, we can now channel, because I hear this so many different times, that we all need to come to a collective agreement. Although English law and your legal estate is an individual right. You cannot form a group first to deal with your individual right. An individual right is the only thing that was created at birth to which then you have to settle, invest. Okay? You cannot belong to a group first. You can't belong to a perpetuity instrument for the very fact and the logical fact that a legal estate is created through a life. It needs a life to be annexed to. Okay? So perpetuity instrument like the Roman Church, jewelry, government, parliament, whatever, are not obviously of life. Okay? They don't hold that interest or can never hold that interest. And if you're a citizen and then complaining about this, guys, if you can't prove that Parliament has no power at all, then you're going to see the circle that you're going to keep on biting your own tail, and you're going to continue to put the cart before the horse. You've got to understand your full rights first. What is law? Okay, or you're just going to fight. You're going to have some wins. I mean, shit, some people do win, but in Las Vegas, but it's designed that way. But when you get to a learned judge, and believe me, that's who you want to get to, you're never going to, you're not going to pass the sniff test. The guy's just going to listen. You go blah blah blah, and then just going to set another date and either think, well, you know what, is it worth even dealing with this character? Or we'll just wait till he hangs himself, or let's just continue to play with this guy and add some more charges and throw him in jail for a psychovel or whatever. Okay, I've been there, done that. All right. Wore the orange uniform. So let's get together. The only thing that can all get us together is individually understand law, vest our interest, and put the power back where it belongs by comprehending where each power belongs. Stop giving it away. And stop, well, I mean, shit, you can do what the hell you want to, but I'm going to call you on it. I'm going to call your bluff, either through you're doing it intentionally, and those who continue to do this even after they've been forwarded material, or those who do it just because they know no other means, which, we'll all get subject to until we start letting go of all of our beliefs, so that we can, come to the purity and the knowledge that's available to us through the perfection that has been ordained throughout history and has evolved through the discussions into what is law. All right, thank you, and God bless in the mannerism that I mean that in each individual as being a God within themselves.